There are a lot of details in the case that are very disturbing, and at this point I don't think it's appropriate for me to go into that. This defendant, under the United States Constitution, stands innocent of the charges that he is facing at this point. He has been charged, and it is nothing more than that. Until the state proves beyond a reasonable doubt and there's a finding of guilt, he stands innocent of the charges that he faces. At this time, on February the 23rd of 2021, the state of Oklahoma elected to file a 5-count information against Lawrence Paul Anderson. 3 counts of murder in the first degree, 1 count of assault and battery with a deadly weapon, and 1 count of maiming. The counts of assault and battery with a deadly weapon and the count of maiming are both with respect to Desley Pye, and in Oklahoma, assault and battery with a deadly weapon is in essence Oklahoma's attempted murder statute. We don't have one that specifically says attempted murder, but we will have to prove that that was the intent of Anderson at the time that he assaulted Miss Pye. As far as the information that led to the filing of these charges, I'm going to be very brief with that. The Chickasha Police Department received a call and went out to take a look at what was going on and exactly what the call was all about. When they arrived, 2 of the officers went in, secured the scene. They found two dead people, 2 bodies, and they also found Anderson, where they put him in custody. Anderson had a couple of superficial wounds to his chest area. He was admitted to Grady Memorial Hospital and later transferred to OU Medical Center, where he received treatment. He's been released. He is housed in the Grady County Jail at this time. Upon an interview with this defendant, with Anderson, the OSBI came to the realization that there was a possibility of a 3rd body. They made contact with the Chickasha Police Department. The Chickasha Police Department went to do a welfare check on Andrea Blankenship, and when they arrived there, they found Andrea dead inside her home, and an investigation at that point ensued. I want to note and thank the Oklahoma State Bureau of Investigation for their services, their dedication, and what they've done in this particular case. Investigator Alvarez was with me in the courtroom this afternoon. She had to leave and go tend to some other business. Investigator Francis had to go to Cordell this afternoon to get a search warrant signed, and he could not be here either. But I will tell you, those 2 investigators have done a phenomenal job, and it's the Oklahoma State Bureau of Investigation that have presented a great case to this office that we're going to be able to use and go into a courtroom and seek justice for these 3 victims. With that, I think there's a question that this case begs, and that is, when is enough enough? We have seen criminal justice reform in the state of Oklahoma now for several years. And I would ask all Oklahomans to ask them a question: do you feel safer in your communities today than you did before criminal justice reform started? And I think the answer to the people in Oklahoma and the people that I talk to in my district is an unequivocal no. We have put politics and releasing inmates in front of public safety. The goal that we have set in Oklahoma is to decrease the prison population with no thought of public safety. And that's not fair to the people of the state of Oklahoma. And we have to come to terms with that. We are increasing, and we are making our citizens less secure and more scared inside their homes and inside their own communities because of some of the things that we've done. In this particular case, with respect to Anderson, and I think everybody in here has seen some of the things that he was charged with. He was charged with robbery in Arkansas in approximately 1998. He was charged in 2005 in Grady County with a distribution case. He was charged around 2004, 2006 in Oklahoma County with pointing a firearm. Again in 2010, he was charged with 4 counts of distribution here in Grady County. In that case, he received a sentence of 35 years. It was 15 years to serve and 20 years of probation. He wasn't in prison very long at all, and he was back on the streets. And in 2015, his sentence, the 20 years, was revoked, and he was sent back to prison. He got out again in 2017, and in 2017, he picks up a felon in possession of a firearm charge, a bringing contraband into jail charge, molesting a motor vehicle, and possession of CDS charges. Those last two are misdemeanors. In that particular instance, all those cases were put together and he received a sentence of 20 years. After 3 years, he appeared in front of the parole board on their commutation docket, and a commutation from 20 years to 9 years was granted. He's released in January of this year, approximately 3 weeks before he committed these crimes. 3 weeks. And he's back in jail again with allegations that he's killed 3 people. It's not fair. It's not fair to this family. I've sat and talked to this family now, and it's not fair to this family. There's a 4-year-old now that's no longer with us. There are members of a family who are never going to see their relatives again. Why? Because Lawrence Paul Anderson was released from prison. Let's ask the families of these victims if they feel safe. And I can tell you unequivocally they don't feel safe today. Why? They see the results. They've seen the results of what's going on with criminal justice reform. What we've done over the last several years is we've taken a prison population that was approximately 27,000 a couple of years ago, and it's been reduced down to about 22,000 today. So there's 5,000 people who were incarcerated who are now out on the streets. That 22,000 number represents about the same number of people who were in prison in 2005. Our numbers have dropped significantly, but we've not looked at keeping people safe. And I kind of like to look at it this way. We look at life and we go, okay, we have the law and we have grace. And today we are too far over into the grace side. You can't have grace without telling somebody that there's a law and you have to obey the law as well. You can't go too far over into the law side because then there's no room for compassion. And I'll tell you right now, some of the most compassionate people that I know in the state of Oklahoma are prosecutors. We take a bad rap, and people are constantly taking a shot at prosecutors all over Oklahoma because, well, those prosecutors just want to put people in prison, and that's all it is. That's simply not true. There's not a prosecutor in Oklahoma that walks out of their office in the evening and thinks, man, it was a great day. I just sent 20 people to prison. Most of us go home with the baggage of having to deal with, well, there's a 4-year-old that was murdered, or there was a 6-year-old that was molested, or there's a 16-year-old that was murdered. And I've handled a lot of cases over the last several years that have involved either juveniles killing somebody or the death of a teenager or the death of a child. And it's time for us as Oklahomans to say, we have an Oklahoma standard and it's time that we do better. If we have the highest incarceration rate in the world, okay, we can look at our citizens and be honest with them and tell them that you're safe. I can't tell the people in my district today that they're safe. And you hear this nonviolent offense, this nonviolent, nonviolent, nonviolent. You hear it over and over again. Well, they're just a low-level nonviolent offense. Go tell these families, the Blankenship and the Pye families, that Anderson was just a low-level nonviolent offender. Look what he's done, or is accused of doing. Those low-level nonviolent offenses don't account for much of the prison population. In fact, the prison population today, 65% of the prison population is tied to 13.1, which are 85% crime cases, or violent cases. So your murders, your manslaughters, your rapes, your robberies, your 13.1 crimes, and the rest of them being violent crimes. Those are the people, 65% of our prison population, those are the people. It sounds to me like prosecutors in the state of Oklahoma. It sounds to me like our deputies, our sheriffs. It sounds to me like law enforcement is getting it right. We're sending the right people to prison. We're not sending people to prison who we're mad at. We're sending the people to prison who are truly troublesome to prosecutors. I think one of the things that has to be done to address all this is we need some transparency in our sentencing. It's really difficult for me as a prosecutor to look at a case and think, okay, I really think this offender needs to serve 3, maybe 4, maybe 5 years. What type of a sentence do I have to walk into the courtroom and get? Sometimes that means I have to go in and seek that 20-year sentence. And I can give you instances here in my district where offenders were charged with distribution, and after 3 years, and take a 20-year sentence, and after 3 years they're back on the street with an ankle bracelet. 3 years on a 20-year sentence should never happen. We need some transparency. We as prosecutors and in law enforcement need to know how much time an offender is going to serve. There's a reclassification committee through the Oklahoma Attorney General's office right now that is working on reclassifying the crimes in the state of Oklahoma. It's a great work, and it needs to be done. And I'm hopeful that the work of that committee will be done soon so that the legislature can take action on their recommendations. You know, we saw just a few months ago in the state of Oklahoma an enormous amount of money spent on State Question 805, and the voters of Oklahoma overwhelmingly rejected that state question. Well, Senate Bill 704 that is pending right now before the Oklahoma Senate is basically State Question 805 minus a constitutional provision, the domestic violence, the DUI, and a couple other things. It's been changed a little bit, but it's basically State Question 805, and it removes my ability to seek an enhancement of a sentence of an offender. I know what's best for my community. These distribution cases today that Anderson was charged with today carry up to 7 years for your first offense, 14 for your second offense, or 20 for your third, 4th, 10th, or 100th offense. Never more than that. And I will tell you what I can see with a Grady County jury, with a Caddo County jury, or a jury in any one of my counties, somebody that is caught selling drugs on the street is going to get 30, 40, 50 years from a jury in one of our counties. This is the way it works. That is the will of the people. We don't want these people on our street. When I campaigned in 2010, I heard two things as I knocked doors. I heard, number one, if somebody has a drug problem, do what you can to help them. I've done that with drug courts and with helping people seek treatment. And two, if somebody is selling even a dime's worth of meth or heroin or anything else, we don't care what it is, bury them under the jail. And we've tried to do that. We've tried to put people who are pumping this garbage into our communities behind bars for as long as we possibly can. Why are we doing that? Because the drug trade is tied to just about every crime that you guys can come up with today. Stolen property, and I'm hearing it every single day. Not just in my district, but across the state of Oklahoma. As you talk to law enforcement, you'll hear them say, stolen property, the merchants, homeowners, and everybody else, property is walking away on a regular basis. Why? Because people are stealing it so they can take it and sell it at a pawn shop, or they can take it somewhere else and sell it so they can get their next fix. The last time I looked at the OSBI crime statistics for the state of Oklahoma, and the value of property that was stolen was in 2019. And in 2019, there was $75 million worth of stolen property in Oklahoma. Who do you think is paying for that? It's coming out of the pockets of every citizen in the state. When that's turned into an insurance company is not going to take the loss. They're going to pass along that loss in an increased rate for homeowners, for car owners, and everybody else. They're going to pass it along to businesses. When the business loses something, that business is not taking the loss, they're passing it on to the consumer. It's causing the price of everything to go up. And it's time that we address it, deal with it, and fix these problems. I want to note, with respect to Anderson, at the time that he applied for the commutation, and there were a lot of issues with the parole board in 2019, at the end of 2019 and into 2020. I was the president of the District Attorneys Association at the time, and I spent a lot of time talking to members, or actually to the director of the parole board, and having meetings with general counsel and what, trying to address some of the problems that we're facing. And one of those problems is this. The parole board was asked to look at over 600 applications for commutations in one setting. One setting is going to be a period of 3 days. They meet once a month, it's 3 days. Think about this. You have offenders asking for leniency, asking for the parole board, asking for the governor to give them a different sentence. And there's 600 of them for 5 people to look over. It's too many. You don't have the time to look through those things and give any meaningful consideration to that. That has to be fixed. In addition, my office, by statute, is required to have 20 days to respond to those applications for commutations. I didn't have 20 days to respond to Anderson and the 15 to 20 other applications that I had to review. While that doesn't sound like a lot of applications, the way that I handle those, that takes up a significant amount of time, because it's not as simple as I can send a letter that says, don't let this guy out. It's go pull the file, go find the assistant, go talk to the investigators, and actually come up with some type of a meaningful review the application, and send a letter to the parole board so that we can express what we believe. In fact, those 15 to 20 applications, we got them so late in the process, we didn't even have the time to review them that month. And we had to go look and go dig for those particular applications. I will tell you today that things are better with the parole board. There's a new director there. His name is Tom Bates. Tom has done a great job. Tom is communicating more with the district attorneys and is working through some of the issues that we've had in the past. Issues with notice, issues with making sure that prosecutors and victims' voices are heard in front of the parole board. I think it's a shame when a parole board member can look at an elected DA or any prosecutor or any victim in the state of Oklahoma and ask them, well, why don't you tell me exactly how much time is enough time for you prosecutors? Well, I'm going to tell you, if it's 20, if it's 30, we know better than any member of the parole board or anybody else what's appropriate for those particular cases. We know more about those cases than anybody else, and there's a reason why we seek those sentences, because we know how long those offenders need to be off of the street. It's also inappropriate for parole board members to advocate on behalf of criminal justice reform, and we've seen that happen too. And that has to come to an end. That bias is wrong, and it should not happen, and it should not be a part of any parole board member at all. I'm going to open this up for questions here in just a second, but as I lead to that, I want to note one other thing, and that is, in this particular instance, Anderson was allowed to waive his parole, and what that means is this. Offenders, and the number was somewhere around 400 a month at some point, were waiving their parole. What does that mean, and why would somebody waive their parole? What that means is this offender has had the opportunity, they've served their time, they're now eligible for parole, and they're given the opportunity to go in front of the parole board. And instead of appearing in front of the parole board, they would be given the option to waive parole. I'm not going to appear in front of the parole board, and they'd be required to serve another 30, 60, 90 days, whatever it may be. Well, that's a big deal when you consider that offender is going to walk out of prison with a discharge sentence instead of on parole. If they walk out of prison on a discharge, they don't have a parole officer watching them. They don't have a parole officer that's requiring them to check in. They walk out of prison and they go home and they continue the life. And there's a lot of people who are released from prison who need that supervision. They need somebody looking over them and watching them to make sure that they're doing the things that the state has asked them to do. In this case, you've heard Anderson and you heard it in the courtroom a little bit ago, extensive record. I went through some of it as well here. I really think an offender such as this should have not ever been able to even apply for a commutation. And when somebody has the record that he has and the Department of Corrections notes that he's a high risk to offend, it's a problem, and that application should have never been heard. And inside that same investigative report, there's a notation from my office that says Anderson should serve every day of his 20 years. And I would ask this: how many times do I have to tell the parole board, the Department of Corrections, and everybody else involved that that offender should not be released? With that, I'll take any questions that you might have.
Just a quick question in terms of factual. So he was serving a 20-year sentence. That was cut down to 9. He actually served 3, though. Is that correct? 3 years?
That's correct.
Total? So the governor signs off on these commutations. What's your message to him moving forward?
So I think what I will say there is I believe the governor is going to want to work on this issue. I've had contact with his office. They have offered to sit down and talk about it, and I think that's something that's going to happen. I think that'll be a good thing. And what I really want to see is that no other Oklahoman, no other family, no other prosecutor, no other law enforcement agent has to deal with the things that we've dealt with in this particular case because somebody was released from prison under these circumstances.
This 600 commutation applications being heard in one setting, was that the same, was Anderson one of the 600, or was this another occasion?
This would have been January 2020. There were more than 600 applications on the docket for January 2020. Anderson was one of those.
So he was one of the 600?
Yes.
And there's not enough time to even give thoughtful consideration?
Well, if you take 3 days, and that doesn't include all the cases that they have to consider for parole. Those were commutations and commutations alone. And if you do the math on it, how much time do you have to consider that application? It's not very much in an 8-hour day. And then when you add in that the parole board has other business and the parole board has issues with parole, there's no way that you can have a meaningful review of that application.
I know you don't want to talk about the facts of the case, but did the neighbors' dogs die? Were they killed too? Or did they survive, or do you know?
My understanding is those dogs are at a local shelter. I believe the family has been given the information about where they are if they want to go get them.
So they weren't harmed. The dogs weren't harmed.
No.
In the courtroom, they had mentioned a competency exam. Tell me what takes place as they go through that process, and then kind of where it would go, given if that was a thing.
Okay. So in Oklahoma, you've got 2 issues. You've got competency, and the question there is, am I or is this defendant competent at this time to understand the proceedings and assist his attorney in his defense? What will happen there will be an application for a competency evaluation that's filed by the defense. If the court grants that, the Department of Mental Health, a mental health facility will send somebody here to evaluate Anderson, and they'll make a determination of whether he's competent at this moment. From there, if he's competent, we'll basically resume proceedings. He does have the right to a jury trial on that particular issue. If it's a jury trial, then we'll have a jury trial and we'll present what we have. If they come back and they say he's not competent at this time and he's unable to assist his defense, that'll be something that we'll deal with at that point. If he is found incompetent this time, it's going to mean send him to a treatment facility somewhere, and that facility will be allowed to restore his competency. And once he's restored, he'll be sent back to Grady County, and the prosecution will resume.
You talked with the family. Yesterday you said death penalty was on the table. Now that you talked to the family, are we closer to a decision on the death penalty, or what can you say about that?
What I'm going to say about this is, obviously, as everybody in the room knows, murder 1 carries death, life without parole, and life. The death penalty is absolutely on the table in this particular case. I do need to finish my review with the family before a final decision is made on it. But I would say I am a heavy lean towards filing that. But again, the family will be consulted well before that decision is made final.
Are you going to meet with the governor himself, or Jason Nelson, or you talked about meeting with the governor's office?
We're working through those issues. Yeah.
would you like to meet with the governor himself?
We're working through all of that right now. Anything else?
Just
Okay.
for, I missed the beginning, could you, just for the recordings, just say your name and spell it? please?
Sure. I am Jason Hicks. That is Jasonhicks, and I am the district attorney for Grady County.